Today my guest is Kendra Marderosian, an attorney in Barrington, Illinois, and I've asked her to come today and talk about a few things that really pertain to real estate transactions. I understand there's a difference between having a power of attorney and being an executor of a will. Can you talk about what the difference is between those two things?
Yes, absolutely. I think the biggest misconception and what trips people up the most is a power of attorney is only valid during someone's lifetime. So a lot of times I will get a call from someone saying, hey, my parent passed away. I am looking to sell their house. I'm their power of attorney. So right there we have to put the brakes on and say, okay, you may have been the power of attorney during their lifetime, but once somebody passes away, that power of attorney ceases to be effective. So if we're going to sell somebody's real estate, what we need to do is then find a different person in a different capacity, or it could be the same person, but we need to find the person who has the capacity to sell the property not on behalf of the deceased person, but on behalf of the estate of that person. So you may have been the power of attorney during a parent's lifetime, but once they pass away, we have to look to the estate planning documents. And to look at the estate planning documents, we're pretty much going to be in one of three scenarios. The parent passed away without a will, the parent passed away with a will, or the parent passed away with a trust. So if we look at the situation where there is no will or there is a will, in both of those circumstances, in order to sell the house, the estate needs to go to probate court. A probate judge will be appointed. The judge will then make a decision as to, if there is no will, the judge will make the decision as to who is going to act as the administrator. If there is a will in place, that person will be the executor of the will is then named as the individual who will act on behalf of the estate. The probate court has to issue what's called letters of office, which is a court order that officially names who is acting on behalf of the estate. Until we have that letter of office that indicates by court order who is authorized to act on behalf of the estate, there really can be no sale of the house. There really can't be a contract signed because, again, we need a legal representative for the estate. The power of attorney is no longer effective. So if that was the only document being relied upon, we need these other documents from probate court in order to proceed. The third scenario is if the parent died with a trust in place. In that instance, there is no need to go to probate court. There would be a successor trustee named in the trust. It's the successor trustee who has the authority, assuming the house was properly deeded into the trust, but it would be the successor trustee who has the authority to act on behalf of the estate at that time. So there is no need for probate court. We would just need to have a copy of the trust reviewed. The title company would request that to make sure that the individual acting on behalf of the trust is actually the person named as a successor trustee. And the other document needed in all three of these scenarios is the death certificate. So again, I think, basically what the misconception is that if you have the power of attorney and that individual passes away, you automatically have the right to act on their behalf after they're deceased. But that just simply is not the case.
Kendra, thank you so much for that information.